They're still together. Yeah. Whatever. I think it's getting recorded, but.
Then let's go on record.
So a very good morning to you all, and this is the first distinguished panelists here, Professor Dr. Shulir Krishnaswamy, Professor Pritam Borua, Professor Samir Kumar Das, and Professor Rukmini Sen. As has been mandated, I will chair the session, and keeping in mind the time constraint, what I will do is I will read out my presentation, my paper, to save time. And the speakers will have 15 minutes each, the panelists, and then we will go on, and we will have the questions, and I think that would be a very stimulating kind of thing to have discussions after the presentations. Now I thank NUJS and its authorities for having me here, for having invited me here. I just want to mention that, it's ironical that I met Professor Madhava Menon not in Kolkata, but in Thiruvananthapuram, when I was a very young lecturer. I had just joined university, and he was so affectionate and so encouraging, even if I belong to somewhat different domain, and not law as such, political science, which has, of course, close relationship with legal studies. So I really would like to remember him here. When we are all, busy in breaking institutions in India now, here was someone who was an institution maker, a great educator of legal studies who had made institutions like this. So I think the times we are in, we must remember him with even more, perhaps with greater admiration. I will speak on constitutionalism and democracy, a dialectical engagement vis-a-vis citizens, and which I don't normally do. I will read it out to save time. On many counts, insofar as constitutionalism and democracy are concerned, it appears to be a close engagement. It is true when one explores slightly deeper into the issue. The moot question is, it is an engagement of what kind? I would submit that the engagement is dialectical, sourced mainly from embedded thought of a particular temporal juncture and from a high pedestal on the one hand, and the changing times, often described as the living reality, on the other hand. Constitutionalism is a lofty ideology. However, it involves varying meanings and interpretations. Let us identify and decode four. Number one, the weakest meaning. In it, constitutionalism is nothing but rhetoric, empty slogan, never pursued in real-time governance. Number two, the pariah. It rests on the argument that it is of liberal Eurocentric origin, which is untenable in the non-Western context. Number three, the minimal meaning. It is the cardinal principle that government in business has to follow the fundamental law of the land. And number 4, the maximal that government can or should be limited in its powers and that its legitimate authority depends on willingly observing these limitations. Thus, the argument goes that the government is to be channeled through and led by the Constitution. It is the last category which is most problematic. It not only raises the question of controlling the governed, but also cautions against the government's own tendency to overstep and transgress individual rights, freedoms, and so forth. And it complicates the matter further by expecting the government to check and balance itself. The engagement of constitutionalism and democracy is rooted in one of the perennial issues of liberal political philosophy: tension between authority of government and rights of citizens. That government would legally limit itself by volition is a great idea. But how practical is it? Especially when it is to be followed in letter and spirit, which entails public proclamation of its own constraints, that is, government's own constraints, without any fine print or hidden transcript. In representative democracy, government comes to power through majority of votes of citizens and it swears by the Constitution. However, what happens if it decides to inflate its power at the cost of the people, often ironically in the name of the people? Does it not indicate evident conflict between constitutionalism and democracy? John Stuart Mill, for one, was emphatic that government has the status of a tenant or delegate. By virtue of being so, its power is revocable if any instance of transgression occurs. People or citizens have a right to rebel, he would assert. However, the reality often reveals a fast transformation in which the elected government acquires the mindset of landlord. Interestingly enough, while constitutions provide safeguards against such trends, there are also constitutional provisions inscribed to neutralize such safeguards. The emergency provisions in the Indian Constitution are an important example in this regard. I would argue that democracy and constitutionalism share the same hardware in more ways than one: parliamentary sovereignty, judicial supremacy, constitutional amendment, periodic elections, rule of law, and so forth. It is the software which tends to generate tension. The software, ruler-rule relations, are exceedingly complex, shifting, ambiguous, and often contrary. At the base, it involves the dialectic of structural institutional power on the one hand, and diffused, dispersed citizen power on the other hand. The core question that emerges from such dialectic is whether constitution is a fixed entity, enshrined forever with authorial intentions, or is it a living entity supposed to evolve with changing social and political values? The question is also to be put in the context of the huge challenge of globalization, in which the state is on back foot. How do the market forces perceive constitution and democracy needs deeper explorations. It is an under-researched theme, at least up until now, in India. There is little need to glorify the emancipatory nature of post-colonial versions of constitutionalism, which is marked by continuity of colonial laws. Upendra Bakshi, in the context of post-colonial legality, observes that colonial laws and repressive legacies are not only retained, but sharpened with regimes of security legislations. This leads to the surveillance state and governmentality, control of population, and all that. Richard Dworkin has been much concerned with constitutionalism and democracy. He dwells with the sensitive question: does constitutionalism subvert or compromise democracy? He does not think it does. He dismisses such thought as illusory on the ground that there is a distinction between democracy and majority rule. Democracy, he says, is legitimate majority rule, not just majority rule. Thus, mere majoritarianism does not constitute democracy. Democracy needs further conditions, even if there can be debates on what the conditions are. Dworkin adds that there has to be some kind of unalterable constitutional structure as a prerequisite to democracy. An example he cites is the embedded constitutional rule that the majority cannot abolish future elections or de-enfranchise minority. A very fascinating intellectual enterprise in recent times has its focus on the interface of constitutions and deliberative democracy. It is also described as a paradigmatic, as a pragmatic development with much promise of untying the knotty, K-N-O-T-T-Y, knotty engagement that is being discussed here. Constitutional deliberation is a particular kind of process based on an event or series of events involving ordinary citizens who are systematically informed and help to reflect on some aspect of constitution making rather than policy making, deliberations about rules of collective life rather than specific decisions within it. Then again, such enterprise is not above criticisms. First, rather than challenging the technocratic visions, a great deal of deliberative effort rapidly became technocratic itself, with focus on institutional design and experimentation, than exploring ways and means of empowering the citizens. Second, it tends to overstate the democratic credentials of institutions based on quota samples of citizens. They take such features as sufficient conditions for deliberative democracy instead of necessary or at least desirable ones, overlooking many other necessary but missing conditions, such as some act of endorsement and accountability of the decision makers. Third, lot of such scholars focus so much on deliberation that they forget democracy, let alone wider relations of power and domination. Small-scale participatory processes, and they also theorize much on mini-publics, might feature a lot of deliberation, and they might be important contributors to deliberative democracy, but they are not deliberative democracy in and of themselves. To sum up, the political dynamics of the engagement I am referring to can be found in the centripetal impulse of constitutionalism and the centrifugal decentering orientation of democracy. Democracy is such a fascinating exercise because it is forever under construction. There is no completion certificate for democracy. It is, as Neil Walker critically remarks, eternally incomplete. We need to go beyond the arithmetical statistical conception of democracy to encourage the political in the sense of being people-driven, citizen-driven. Otherwise, we the people will be interpreted as they the people. In that case, Bertolt Brecht shows the way in his poem. Many of you have perhaps read the poem, Solution, which was written by Brecht in 1953 when there was certain kind of political turmoil in Eastern Europe. Now there the poem ends with this idea that when citizens have forfeited the confidence of the government, would it not be better for the government to dissolve citizens and elect another? Thank you. So now the more serious panel. And we will go by the order that has been given to me.
Are both timely. Professor Menon was awarded the Padma Bhushan of what was it, a week or 10 days ago, and a commemoration of this sort would certainly be the first after that award. But it's also timely in that the resurgence of interest in the Constitution and on questions of citizenship are, I think, historically unparalleled, at least in this republic. And so it's a good time to be having this conversation. The title for the panel is Citizenship, Democracy and Constitutionalism. I might put a comma between citizenship and democracy and constitutionalism, because I think they're two debates which have historically not been related to each other. And I'm going to try in the next 10-12 minutes to show why asking the question in this particular way is both interesting and novel, not just for Indian constitutionalism, but for constitutional theory more generally. That's where I want to go. Let me begin, though, in a very pedantic place. When I was a student of constitutional law at the National Law School in Bangalore, Part 2 of the Constitution was never taught. We had 3 courses in constitutional law because of the peculiar academic structure at NLS. But citizenship was never a part of any of the 3 courses. When I came back as a young teacher, I had to puzzle out where I might place citizenship in the debates. And I had, to my mind, 2 options. Either I place it in the very first introductory course in constitutional law, where we might teach the 2 primary entities of the Constitution, the state and its citizens, together, or that I must place Part 2 in a discussion about the scope of Part 3 and Part 4. And that's what I did. So when I taught the course, I taught it as if it were a part of a discussion about fundamental rights. And I had an elaborate reading list, as some students know, too long for their own good, or maybe for my own good. But I explored this question at great length and looked at the early formation of citizenship law around essentially 2 questions. First, the partition of India. Second, Kashmir. And third, the Northeast. So if one looks at the corpus of case law, and I'm taking a very narrow sliver of the material on citizenship, just looking at the corpus of case law, these are the contexts that shape our legal understanding of citizenship in India. Now when I look back at how I initially taught constitutional law, I think I made something of a mistake. Because it's a mistake to analytically locate citizenship as a sub-part of a debate about fundamental rights. I've now come to understand citizenship to be much like we might understand property law, as a bundle of rights, of which there are many parts. And let me just run through a few of these. It might be useful and illustrative as we think about this question, because I don't think this question is going to go away too quickly in at least the Indian political context. We have a lot of time to think and work through this idea. Clearly, Part 2 needs to be taught by itself, but Part 2's citizenship texts, Article 5 onwards, are not very elaborate. Some people try to argue that Part 2 institutionalizes or distinguishes between a jus soli and a jus sanguini model of citizenship by allowing for a recognition of birth, but Part 2 does other things too. It allows for processes of naturalization, maybe through subsidiary legislation, and so on and so forth. It's not clear that Part 2 determines this question as to what is the model of citizenship. We certainly must teach citizenship in the context of Part 3 and Part 4, which speaks variously in terms of persons, citizens, and groups. So we have 3 kinds of language, all of which invoke the people, and citizenship is one part of that language. Most people are very comfortable talking about the relationship between Part 2 and Part 3, but less so the relationship between Part 2 and Part 4, which also invokes the collective peoples in various ways. Part 4a, our fundamental duties, seem to have received something of a revived attention. It's ironic that the last time Part 4a received so much attention, we called it a political emergency. But today, there's a resurgence of interest in the political vocabulary around who has what duties, rather than a conversation about who has what rights. Part 15 of the Constitution, which talks about elections, deals with a very important part of the citizenship bundle, which is about your right to vote. Now, Part 15 doesn't arbitrate between who gets to vote and not, but places some general principles of both non-discrimination and universality into the electoral map. Clearly, one very important citizenship right is the right to vote. There are some who might argue, as the op-ed pages of the newspapers confirm, that all of the conversation we are having is essentially a conversation about who gets to vote. Right? Because the Part 4 part of citizenship, which might be about what we might be entitled to as a matter of welfare, or the Part 3 chapter, which might be about what we are entitled to as rights, are somehow less important. What's driving our current debates is primarily that part of citizenship which deals with who gets to vote. And so, at least this range of the Constitution is essential to understand citizenship. And I'll repeat 2, 3, 4, 4a and 15. Maybe there's more. There are more ways of reading citizenship into the Indian Constitution, which we must both explore and understand at greater length. When a constitution and its text don't settle contemporary political questions, there is a tendency, both in legal scholarship and in political scholarship, to think that the answer might lie by a strategy of looking back, which is that history will provide us answers to questions that the current constitutional text does not. Where would we go? We might go to proximate history, the framing of the Constitution of India, which is quite accurately recorded in the Constituent Assembly debates. We might go further back to a kind of long history of Indian constitutionalism, maybe 1885, the first text, in some sense, draft text of an Indian constitution. Some like Bailey would take it even further, and all of these are valuable resources. But there's been a tendency on both sides of the political aisle on this debate to trot out this or that quotation by somebody. You can choose Gandhi or you may choose Ambedkar, to try and argue that this debate, that is the debate about citizenship today, can be settled somehow by a reference to historical resources. On some questions, this is a valuable strategy. Unfortunately, on the question of citizenship, I would argue that this is a failing strategy. Why do I say so? I think that the primary political issue on which the citizenship debates in Indian politics, I'm talking about pre-constitutional politics, were framed was on the question of Pakistan. And whatever else we might learn from the formation of the state of Pakistan and the division of the Indian subcontinent, the only valuable lesson we can learn is a lesson of failure. That is, a negative lesson. In the hagiography of our constitutional pasts, this gets less emphasized. That sometimes we must look to our constitutional past to learn how we have failed, not that we have succeeded. So, at least on the question of Pakistan, and the idea of having a religious faith-based nation and a religious faith-based model of citizenship, Pakistan, the creation of Pakistan, represents the failure of Indian constitutional imagination. The failure in the first instance to develop a federal model that could accommodate religious diversity as we have developed a federal model to accommodate all other kinds of diversity in Indian constitutionalism. And second, the failure to recognize that a nation, that a political nation, could be built by eschewing all models of religious identity-based citizenship. These are two failures that Pakistan, the formation of Pakistan, represents. So it's not clear to me that the harking back strategy, the looking back strategy, offers respite. And to the many scholars in this field, and I can see some versions of this scholarship spilling out onto the newspapers, who think that really what matters here is a better history, meaning your history is not good, my history is good. So if I dig out the right source, somehow I settle this debate. I'm going to show you that citizenship in India was never meant to be what it is here. Is not a working strategy for me, because and this is a history I know fairly well, and my familiarity with that period suggests that there's going to be no winner here. So if looking back and framing this question historically is not a bright start, where would I go? And so let me suggest that just as a strategy, let's try and look ahead or look around, and let me suggest two versions of both these strategies. And I suspect that the debates around citizenship can benefit from both these strategies. So we must remember that the debates around citizenship and membership in political society in India in the 1930s and 40s were framed under a colonial legal regime that had no serious constitutional constraints. You might take the 1935 Act to provide some constitutional constraints, but not serious constitutional constraints. Today, we have that debate under pretty onerous constitutional constraints. So in other words, in the 1930s, the question of citizenship was meant to be resolved by a political regime of majoritarian democracy, where the votes are or where the voices are. In 21st century India, that question has to be settled in a position of constitutional democracy. I think Professor who just finished already took us through Dworkin's discussion about what the distinction might be between a democracy and a constitutional democracy, and that constitutional democracies place serious fetters on majoritarian politics. How does that leak into questions of citizenship? Let me suggest that while the question of the formation of Pakistan and the question of citizenship and membership in the two political entities was left by the British to be primarily a question to be sorted out at the hustings at the electoral voting booth in the provincial elections that succeeded the 1935 Act. In India, 21st century India, that is not a question that can be resolved at the hustings. It is not a singularly electoral question. So it has some serious constraints. So if we are going to decide, and I think Preetham is going to argue that Assam is not a peripheral case, but a core case. But for the moment, if Assam is the case around which citizenship questions are going to be determined in India, this argument cannot proceed on primarily on democratic, if that means electoral terms. The electoral debates are secondary to the constitutional constraints. So it has been, at least for the last 30 to 40 years, argued in India that that these democratic upsurges for various forms of representation in the Northeast and the need to protect various forms of identity are somehow both indigenous and hence legitimate. At the very least, they will need to satisfy another test of legitimacy, which is the legitimacy constraints of constitutionalism. And for far too long in Indian debates, at least about the Northeast, this constraint has not been seriously understood or applied. Let me conclude on why we must look around. So I'm saying we look forward, we try and understand what constitutionalism and democracy means in our current moment. There's no point looking back. I don't think that history is going to save us. But looking ahead could also help with us looking around. And here it's not surprising that debates about citizenship and immigration are sharp in the United States and in India at around the same time. And we might ask, what is it about the second decade of the 21st century that these kinds of debates have come to the fore? We already heard that a reference to 1930s Eastern Europe and Germany, and we might want to pay very careful attention to those debates, because it seems like Hannah Arendt, in her masterful text on the origins of totalitarianism, and the Schmidt-Kelsen debate on the Weimar Republic teach us a lot more about our political present than anything that we can learn from 1930s Indian history. So my resource then, for thinking about these questions, is more Schmidt-Kelsen and Arendt than what Nehru or Gandhi or Jinnah might have said. I think that these texts are much more salient and important. We generally, and I'm going to conclude with this, what the Schmidt-Kelsen debate alerts us to is that we generally think about the problems of liberal constitutional democracy as to be problems relating to two kinds of questions. Either the relationship of fundamental rights to the state, that is, what limits do fundamental rights impose on the state, or problems of the separation of powers, meaning what are the powers of the executive and the legislature on the one side with the judiciary on the other. We haven't learned to think that constitutionalism and democracy fault lines can be found on the very question of membership. Who belongs in a political society? This is not the question that we conventionally associate with a constitutionalism and democracy debate. So going back to, the Alexander Bickel kind of separation of powers questions and, all the historical materials that we're used to thinking about, John Hart Ely and Bickel and the American constitutionalists on these questions is not helpful, because none of them focused on this question of the membership in political society and how that relates to constitutionalism and democracy. And hence, it seems clear to me that the core resource that we have to turn to is the 1930s debate in the Weimar Republic. If we don't go back there, we are left without foundation, and we'll navigate this despite, I know that there is great enthusiasm about the public recitation of the preamble and that kind and these forms of protest, and I think this is all very good. And if that kind of excitement and engagement with the Constitution can be sustained, it can only be sustained based on the work of quite rigorous sifting through of the fault lines of the limits that constitutionalism places on democracy on as fundamental a question as membership in political society. Let me stop there. Thank you.
Of citizenship in the Indian Constitution, and provides a very challenging and very interesting strategy of reading citizenship, making a critical reading of the dominant mode of interpreting history in very positive terms, highlighting our deficiencies there and failure there, and identifies the fault lines between constitutionalism and democracy, keeping in mind the core question, the membership in political society. And it's really good to see. I mean, I ended my presentation with Brecht, Weimar Republic, and he took it from there and elaborated it. And that's why I think, this also leads to a kind of epistemological, I think, point that we must go beyond our confines of perhaps indigenous readings and borrow from, other sources, like he mentions Adam and all that. Thank you. And now I move on to, I request Professor Preetham Barua to make his presentation.
Me to speak here, and I think this is a wonderful intellectual initiative and a fitting tribute to the legacy of Professor Menon. I'm also happy to be here in NUJS after around 10 years. Sudhir and I and Rukmini overlapped when we taught here. Several of our students are now teaching here. And I also felt that it's an institution which has the legacy of the likes of Professor Menon, Professor Chimney, Professor Singh, a rich legacy in legal education and constitutional law. We are at an interesting juncture when the important debates about constitutions and constitutionalism and democracy and citizenship have now not only questions of constitutional validity, which has been widely discussed, but also the tension between constitutionalism and democracy, which Sudhir has highlighted, and he has written on, he has a book on it, but also something which one of the NUJS alumni, Moez Tundawala, who was earlier a student, now a colleague, has said in a piece in The Wire, that the question is as much about the tension between constitutional processes and the exercise of sovereign power that radically alters the constitutional understanding of what are the constitutive norms of the Indian polity. So I think what Moez has said about the propensity of the state to exercise almost a sovereign power in questions which ordinarily would be spoken in terms of constitutional limitations is something that both Indian constitutional law and politics needs to think about deeply. Now, in other words, the kind of constitutional politics that we see through the CAA and the NRC and the NPR, they are actually question of what articulates our shared constitutional imagination. And that is the question, I think, which puts us at a critical juncture. So in the 10 minutes or so that I have, I do not want to only address the widely debated topics about the constitutional validity of the CAA. It has been widely debated in journalistic forums, in journals, so that's not something I would like to focus on. But I would like to draw upon some theoretical resources, which is my own area of work, which is on how constitutional values have an interpretive weight in how we understand the constitutional validity of the CAA. Now, constitutional values, I think, are interesting as opposed to specific constitutional provisions. Most of the values we first go to the preamble, but we also find them in different parts of the Constitution. They are often invoked, even by constitutional courts, only as rhetorical devices. For example, my own work of human dignity, I've come to learn that courts use these constitutional values very casually in a way that actually enables them to justify whatever conclusions that they want. And you would see that in the debates over the CAA, constitutional values somehow have again come to the forefront, both in arguments from the government as well as by the hundreds of, say 150 or so petitions which are there in the Supreme Court. So I want to focus first on some of these constitutional values and how through that lens we can look at the CAA. Second is, I want to also look at some other constitutional concepts which Sudhir has already touched upon, which are federalism, asymmetric federalism, and the question of how does the Indian constitution deal with cultural diversity. I think these three need some amount of rethinking, especially in the context of the states in the northeastern part of the country. That is something that I will comment upon. And the third is that the present experience, I think, calls on us to be skeptical of a thick, substantive concept of democracy, which is to say that everything good that we find in the Indian constitution or in our constitutional imagination has something to do with democracy. And as Sudhir has pointed out, I think there are concepts and values other than democracy which are important, mostly because it is electoral democracy and a substantive understanding of democracy as the most important source of legitimacy which has landed us in a difficult situation today. So these are the three broad areas that I'll quickly comment on. Now, on the constitutional values, I think one of the values which is of prime importance when thinking about not the CAA but the NRC is the idea of a republic. So that's there right in the first sentence of the preamble, and it says that whatever else India is a republic. And usually the word republic again is used as a rhetorical device, but there is rich literature and there's burgeoning literature in constitutional theory on republicanism, and there are different variants of republicanism, but at least there is some loose agreement amongst the various scholars of republicanism that republicanism centers around two important concepts. One is the idea of consent. I think that's a weak argument, but the idea of consent as a part of the legitimacy of government. And the second is the idea which justifies consent, which is the idea of non-domination, that citizens' autonomy will not be dominated, which is will not be dealt with unjustified authority. So autonomy can be taken away, but on grave justifications, not easily. Now, at least many Republicans, the paradigm cases of Republicans agree on this. And if you look at the NRC process, whether it was in Assam or the new one which is going to come in through the NPR, you see that it is a complete inverse to what is, I'm not sure if this is working, is this? Yeah, okay. Of what Republicanism says. At least in the case of Assam, the burden was on citizens. Not citizens now, everybody was suspect. The burden was on people to go and prove their citizenship. And through the NPR process, though there is an intermediary now, which is the NPR, the burden is still on citizens. Not citizens. Burden is on residents to prove their citizenship. So the flow of logic here is almost opposite in the sense that this is not justified by any idea of non-domination, but clearly an idea of domination where the state uses its coercive power to ask people to prove their claim to constitutional and legal rights. Ordinarily, the logic in law is that if you want to deprive someone of constitutional or legal rights, there is a reason for doubt, which is usually by facts, and the state has the burden to prove these facts. Now, people in Assam were very happy when the IMDT Act was declared unconstitutional, but perhaps it had some Republican sense to it, that it's the burden of the state to go and detect whoever you think is suspect of not deserving our rights, right? And the question of membership then is put on the state, that you have to prove who is not a member rather than asking people to prove that they are members. So the question of the idea of republic, I think, demands that we question this process of how you are going to detect illegal immigrants. And that process has a lot to say about how we interpret the concept of republic in the preamble to the Constitution. Now, the second value that I think deserves reflection is found in a string of ideas in the preamble, which are about fraternity assuring the dignity of the individual and the unity and integrity of the nation. So this is a short piece that I had written, in the wire, but where I was trying to argue that if you look at these concepts, which is fraternity assuring the dignity of the individual and the unity and integrity of the nation, these are all loaded moral political terms. Even the idea of unity and integrity are not references to territory. If you looked at legal theory, the questions of integrity are mostly questions of morality. They are not questions of what is the integrity of a territory. And in that sense, I think, in S.R. Bommai versus the Union of India, I think the two NUJS graduates had written a wonderful piece in the NUJS Law Review, if I'm not wrong, on what does this idea of fraternity mean. And the idea of fraternity, at least in S.R. Bommai versus Union of India, laid out an intrinsic link between secularism and fraternity, which was to say that secularism promotes fraternity in the sense that it makes people recognize common bonds between them rather than reasons for division between them. And this idea of fraternity is there to assure the dignity of the individual. And they seem almost like platitudes, these terms, but I think they have real constitutional impact in this sense, that when you speak about fraternity and dignity in terms of the individual, then we realize that all the rights which are connected to these values of the Constitution, the specific rights that there are there, apply also to illegal immigrants. So there is a legal argument floating around that illegal immigrants do not have the universal fundamental rights. And the list of these universal fundamental rights is actually quite long: 14, 17, 21 to 25, 27, 32. None of these say citizens. They all say persons. But there is an argument now saying that these persons are also those who legally entered India. Now that is, I think, a mistaken argument. Because you can't imagine saying that Article 17 does not apply to illegal immigrants, so we can treat them as untouchables. You cannot imagine saying that the ban on child labor is something that won't apply to children who are illegal immigrants. So in that sense, I think this argument does not get off the ground. So there is, and we must understand that when the Indian Constitution was being drafted, the background was not just the Indian independence movement. The background was that there were a number of other constitutions which were drafted around that time, and there was, how do I put it, the Universal Declaration of Human Rights actually had a great bearing on a drafting of a number of these constitutions. So if you compare the Indian Constitution to that of Germany, the similarities are great in the sense that some rights are available to all individuals, not just to citizens. And I think in the case of the CAA, this argument would be important, because if 14, 17, 21 to 25, 27 and 32 apply to illegal immigrants, then it is difficult to defend a law such as the CAA. Right? The argument becomes much stronger for declaring the law to be unconstitutional. Now, some others have also argued on the constitutionality of the law and said that it is the distinction is on the basis of a theocratic state and not on the basis of religion, which I think again is a flawed argument, because you have not chosen theocratic state, you have actually chosen people from theocratic states, and the people you have chosen are on the basis of religion. So in that sense, the argument from a theocratic state also does not get off the ground. And the third argument which has been floating in journalistic forums is the argument from under-inclusion, which is that just because you don't include certain religions, it doesn't mean that your law is discriminatory. But the unit of comparison is about two illegal immigrants in the country, not people who are potential illegal immigrants. If the unit of comparison is two illegal immigrants in the country, then you can clearly see that religion and place of and nationality, which are almost immutable, mostly immutable characteristics, do have a discriminatory force. So in that sense, I think if we read the constitutional values for what they mean in the Constitution, then there is a strong case for the CAA to be unconstitutional. Right? So this is how much?
2 minutes.
Okay. So in that sense, I think if we really looked at the values of what it means to have integrity, which promotes, say, unity and integrity of the nation, then we must look at these terms as moral terms and not merely as those signifying the territorial, integrity of India. The second point which I wanted to make was about Assam. Usually, the term that has taken is as Assam is an exception because of the NRC. It's okay to have the NRC in Assam, not okay to have it in the rest of the country, right? But if we looked at the realities of Assam, you would see that the NRC was as anti-republican in Assam as it was in other places. But we must also recognize that Assam does face a serious question of immigration. A number of scholars, who have visited Assam from other parts of the country, have said that perhaps the question of illegal immigration is not very important. But if you look at data from, not only census data, but there are scholarly works right from 1840s, there was again in 1890, the 1911 census, 1920, 1930, 1947, 64, 70, these all saw spurts of immigration into Assam. And for the first time, when the Assam Accord was signed between the Indian government and some stakeholders in the movement, you would see that the immediate solution was not deportation. The solution was that most people who came up till 1960 were to be regularized as Indian citizens. Between 1960 and 1970, people would not be able to vote in simple terms for 10 years, but after that they could register. So the response of the Indian state, even in the case of Assam, was not one of deportation, but one of recognizing the humanitarian crisis in the case of immigration. And that legacy must be carried forward in thinking about the immigration problem today, which the CAA is trying to address. Because what happens if you're not on the register of citizens? And this legal power has been there for a long time. So the only indication is factual, that we are building detention centers. So maybe that's the one where we are going. But surely the law doesn't have much to say on this. The second, quickly, if I have a minute or two, on Assam, the other kind of problem which I think we must have a theoretical framework to think about what's going on in the Northeast is that at least the state of Assam faces what I call constitutional impoverishment. The problem, the greatest threat to Assam is not only from illegal immigrants. It is because they are surrounded by a large number of communities who have protections which incentivize them to speak to the Union of India and not to their neighbors. And this argument I have made earlier, that the 6th schedule was the wrong kind of constitutional instrument to be applied in a culturally diverse area. The Northeast is a microcosm of the country. The kind of diversity you have there, you would say that yes, India, look at the diversity in India and look at the diversity in the Northeast, it's almost like a mini India. But what did you do with the constitution, your constitutional instrument? You said that if you can prove that your autonomous district councils, in order to get your autonomous, government, in order for you to get central funds. So it became imperative on the Northeastern communities to fight against each other to get favors from the union government, and which has again happened just now with the Boro Accord, right? And if you look at the Boro Accord, the idea now is that there is going to build, there is an autonomous government, but the Boros are in a minority in that area. They are only 30% of the population. The others are non-Boros. So there is a politics of division happening on the basis of the constitution, in which I think the 6th schedule is guilty of really impoverishing this region, where maybe a constitutional value like fraternity would promote some other constitutional instrument where each tribe is forced to talk to the other and not prove the others as someone who's an enemy in order to get benefits. Right? I have overshot my time, so just this last point on the theoretical question which Sudhir rightly pointed out. I think that a lot of constitutional law scholars in India think that democracy is a substantive concept. So all our fundamental rights come within the concept of democracy. And I think that a traditional understanding of democracy merely as a form of representative government is a kind of idea we should try and push. That's because then it makes us appreciate the independent values of expertise, accountability, independence, transparency, which are all basis of political legitimacy. Democracy is not the only basis. And that kind of constitutional law thinking, I think, deserves importance today, because it is electoral democracy which is the basis of the citizenship crisis that we see today in India. So more focus on those constitutional values deserve importance. Thank you very much.
Thank you.